So if you don't have a good understanding of what the boilerplate means, because it's the kind, usually when you're doing an agreement, nobody even reads it. So you have to kind of know what it says, so you know if you have to add anything. So we're going to go over some standard boilerplate paragraphs and then some examples. Let me share my screen. Oh, wrong screen. Okay, this one. Okay. No, not that one. This one. Okay. Okay, so this is a list of boilerplate, of general boilerplate provisions. And then we'll look at how it actually plays out. Okay, choice of law. So in every contract, again, every single one of these things came from a lawsuit where somebody sued and the court found that, gosh, you didn't put in this, and so therefore, you don't get to pick, or you don't get to choose, or whatever. Somebody lost a lawsuit because they didn't have this information in their contract. And so from then on in, everybody puts the information in their contracts because they don't want the same thing to happen. So choice of law is, which law are we going to use? When we have a lawsuit in California between two Californians and it's over something that happened in California, we don't really have to look very far or to make a choice, because it would just be California. But if we needed to sue someone in Nevada, or someone in a different state was suing us based on, or you're signing a contract, that's where it usually comes up. You're signing a contract with a vendor, a provider, and their headquarters are in St. Louis, right? So you're going to see in their contract, it's going to say the choice of law is in Missouri, right? St. Louis, Missouri. In Missouri. And if you live in California and you see that in a contract, because that's the way it was presented to you, you have to know that if they do something wrong, you're going to have to go to Missouri and sue them. Okay, so choice of law is choice of law is whose law is going to be interpreted to decide who wins or loses. Okay, so if everything's a California question, of course, California law is going to be used. But if there are more than one state involved, or people from more than one state, then you have to decide whose law are we going to use, California or Missouri, or whose law. Then the next one is jurisdiction. And jurisdiction is which court. Okay, so you could have a case where the jurisdiction is in Los Angeles Superior Court, but the choice of law paragraph is Missouri. Okay, so you could still file a lawsuit here if the choice of law was Missouri, but the courts in California will determine it under Missouri law, even though it's taking place in California. So you can have two different things for choice of law and jurisdiction. But jurisdiction is super important, because even if everyone's in California, jurisdiction in California is by county. So we don't give jurisdiction anywhere in the state. You can't have a lawsuit with someone that lives across the street and go up to San Francisco and file it to make it difficult. You have to file it where they live. So but in California, there's many counties. So if you are in Los Angeles County, you might put jurisdiction is in Los Angeles County, California, which means a court in the county of Los Angeles has to hear this. Or you could pick any county you want, but that's how it's decided. And these are almost in every contract you will ever read. Okay, sometimes they're combined, but almost every contract will have a choice of law provision and a jurisdictional provision, because how else do we know where? If there isn't one, then you can sue anywhere you want. Okay, indemnification. We'll cover the cost of certain disputes. Okay, so indemnification is the part of the agreement that says that if you sue me, the prevailing party is entitled to attorney's fees. If one party sues the other, it's not the party who sues that's entitled. It's not one party or the other. It's whoever wins the lawsuit. And again, that usually is in there somewhere, because if you want to make sure that you're going to be indemnified, you have to have this in your contract. Okay, warranties. Warranties often are not considered boilerplate because there are real warranties, right? There is really something to say. But if you're doing a general blanket warranty, seller does not warrant anything, or does not warrant that this document, you know, is what it says it is, or does what you think it does. But again, when it's specific to something in the thing, it's not boilerplate. It would only be a general warranty statement. I think that's more often than not boilerplate, but I could be wrong. Okay, confidentiality. Again, you won't see that in every contract. Every contract is not confidential. But if you want it to be confidential and not to be shown to anyone else, then you would have a confidential. And again, it's not specific to your whatever you're settling or doing or agreeing to. It's really just general. In general, we're going to agree that this is going to be confidential and that you can't share it with anyone other than your tax preparer. I mean, a lot of times settlement agreements are confidential. If someone has an agreement, they get terminated, they sue for wrongful termination, and there's a settlement agreement, those are usually confidential, and you can't go around telling people what you paid and what they demanded. Okay, waiver. Future clips. Okay, parties. See, I guess this is boilerplate. I never really thought of it as boilerplate. Okay, permits the parties to forego or give up the right to sue for a breach of agreement without any future claims. And that's a standard paragraph that goes in almost every contract in California that basically says that this agreement covers everything between the parties and there's no outside agreement that's going to cover, and you agree, parties should give up the right to sue for breach of contract. Right, you agree that we are waiving every claim we have against each other up till the date we sign this. Okay, everything. California has a law that says you can't waive something you don't know about unless you say, I'm going to waive everything I don't know about as well. So you're going to see these clauses are going to say, whether I'm aware or not aware, I'm still waiving everything up till this date. Okay. It's a standard provision in almost everything. Okay, limitations on damages. If you agree that if this is the liquidated damages, okay, if you agree that if the buyer is damaged, there's an automatic, or if one person's damaged, there's an automatic payment or an automatic, that's liquidated damages, which I'm sure you're all familiar with because it's in our contract, our purchase contract. Okay, force majeure. Oh, you'll see this in big, long contracts, not in like little short contracts, but it'll basically, like in leases, you'll see a force majeure if, or if there's an earthquake, flood, and the property can't be used anymore for the purpose it was established for, then the agreement's suspended, right? If yesterday we would have had a lot more winds and it would have knocked off some tenant's roof, clearly the agreement for the tenant to pay rent is going to be, and so you'd want to put that in there. If any of these things happen, again, this is not in every contract, but it's in some contracts. Okay, attorney's fees and costs, you'll see that almost in every single contract you'll ever sign, because there's a law in the state of California that says that I don't think it's a law, I think it's case law, but it says that a party in any lawsuit is not entitled to their attorney's fees if they win, unless there's a document in writing that says that they get their attorney's fees. So if you drafted a contract without an attorney's fees clause and there was a lawsuit, each party would pay their own attorney's fees, even if they win. Okay, that's why these are in here, because people don't want that. They want it to be a deterrent. If you sue me and I win, you're going to pay my attorney's fees. Okay. Arbitration, if you want to have an arbitration clause, then you have to have an arbitration clause, and you can have an arbitration clause again. We have an arbitration clause in our purchase agreement, and so you're probably a little familiar with arbitration clauses. Okay, a jury trial waiver. Okay, so sometimes in a contract, if it's like a vendor or somebody like that, they might put in that the parties waive jury trial. And that's to save money in the long run, and because we think it's crazy because this is a vendor thing, and either the product was no good or you didn't pay, and that's why we're suing, and we don't need a jury for that. So we're going to agree to keep our costs low if we do have a lawsuit and have not a jury trial. Jury trials cost $1 zillion more than bench trials. Okay, severability. You're going to see that in every single one. Again, there must have been a lawsuit where someone didn't have it. It permits the court to sever an invalid position and keep the invalid provision and keep the rest of the contract. So you're going to see that it's going to say, the parties agree that if any part of this contract is not legal or enforceable, it'll be thrown out, but the rest of the contract will be enforced, something like that. Attachments and exhibits, again, I don't find that to be boilerplate, because that's part of your, if you're attaching something or an exhibit, it's part of your contract. It's part of what you're doing here. It's not just boilerplate, but okay. I don't know. Escrow, I don't even know why it's blue and why it's different than the others. But if you're gonna escrow money or place payments in a special account, but again, I don't think that's boilerplate. I think that's part of your agreement. Okay, notices, you'll see, I'm sure you've noticed it in every contract we ever do. There's always a provision for notices, where to give notice to the two parties if you have to give notice. That's boilerplate. Relationships. This prevents either party from claiming a business relationship. Okay. So sometimes you're doing something and you don't want to be associated with the person. You have this, I don't know. I don't know about this one. I don't think I've ever drafted anything that had a relationship boilerplate. I feel like, again, that would be very specific to your transaction. Headings, always a headings one. The clause provides that headings used have no significance. So if someone makes a heading and then the writing says something that you find inconsistent with the heading, it doesn't matter, because the headings don't matter. And it has to say that, okay? If it doesn't say that in your contract, someone could make the argument that they were misled by the heading. And that's why there was a lawsuit where that happened. And so now everybody puts this in. Okay, integration. You're going to see that in everyone too. The written contract represents the final agreements of the parties, and there's no other document that that is included in anything that we agreed on orally up till now that's not the contract. It doesn't count. So it's an integration of everything we did into this one document, and that's pretty standard. Yeah, counterparts, you'll see that too. Again, there must have been some lawsuit over this, but it basically allows the parties to sign in counterparts. They don't have to sign the same actual piece of paper. One can sign one and the other one can sign a different piece, and we'll just put both signature pages together. We get a lot of things signed in counterparts. Sometimes we put the agreement in and sometimes we don't, but as long as it's signed by both people, honestly, who cares? Okay, so let's look at some examples. Okay, this is a short form. You can see I just did a short settlement and release agreement. Somebody owed money or decided to pay someone money. And so we do very simple ones, okay? In the event a party files suit to enforce or interpret the agreement, the prevailing party shall be able to cover their attorney's fees and costs. Okay, we always want that in there, because why should you sue me and I win and then I still had to pay all that money? And just for the record, the court doesn't necessarily give a party dollar for dollar attorney's fees. The court decides what they think is fair and awards that. The agreement shall be interpreted under the laws of the state of California. So now we know whose laws we're using, right? Choice of law. The agreement shall not be amended except by a writing signed by all parties. So no oral amendments. So if they say, well, we agreed on this after we signed, it doesn't matter, because we have, our agreement says that we're only going to be amending by written agreement. The agreement shall be deemed prepared. Oh, this one didn't really come up before, did it? The agreement shall be deemed prepared jointly by the parties and shall be interpreted under the contract laws and not construed against either party. This one's really important, okay? Because this one says, and most of the time one party drafts the agreement, right? It does not drafted by two people. The two people don't sit down together, the two lawyers, and draft it. One drafts it and they send it to the other, but the other can make changes or whatever. I mean, it's a negotiation. So we say that it was prepared by both parties, because if we don't put this in here and we drafted the agreement and it's somehow ambiguous, it's just construed against us because we drafted the agreement. Therefore, if it's not clear, it's against us. So whatever the other party says they think it said is probably going to prevail. unless you put this sentence in that says they were jointly prepared, it was prepared jointly, not by one party or the other, whether it's true or not, and shall be interpreted under the contract law and not construed against either party. Okay, so we're looking at contract law. We're not going to go after the person who drafted it and say, well, you drafted it and it's ambiguous, so let's see what the other party wants to do. The parties are advised, oh, that wasn't on the other one either, but we like to put this in too. The parties are advised to consult with an attorney of their choice prior to executing the agreement. This little sentence right here protects so much, so that someday when there's a fight and you'll say, well, listen, we told you that you should consult with an attorney before you sign this. We didn't try to sneak it under you. We told you to do this. So these are all, there's not very many on this agreement because it's probably a personal injury or something, or a property settlement agreement. But these are all super important if they're, if they're missing. Okay, I think I have that one, this one. Okay, so here I'm going to put this up a little bit. This is an agreement. This is a purchase agreement. Okay. They have what they call miscellaneous provisions, which is normally what we call the boilerplate down here. But you'll see they talked about payments of costs and expenses. They talked about some of these other things in that article. But see, they're not, until you get to here, they're not boilerplate. Okay. Attorney's fees. So this is how they sell it. If buyer or seller brings any legal action regarding the provisions of this agreement, the prevailing party in the litigation shall be entitled to recover reasonable attorney's fees from the other party, reasonable, in addition to any other relief that may be granted. This provision applies to the entire agreement. Buyer and seller were each represented by an attorney in the negotiation and execution of the agreement. Okay, whether they were or not, and I happen to know in this case, neither party were, but they put that in here. Okay, so that's attorney's fees. We like that in there because we don't want to be, if we get sued wrongly, we do not want to be stuck with the other side's with our own attorney's fees. Okay, survival of agreements. These are subject to express limitations contained. All covenants, agreements, representations, and warranties made in this agreement shall survive the execution and delivery of the agreement and the consummation of the transactions contemplated by the agreement. Yep, what's this? A bunch of goolly-gop, right? So basically what it says is all the agreements we made are gonna still be our agreements even after we execute and deliver the agreement and we work on it and we consume it. We do what we're supposed to do. I don't know. It seems to me goes without saying, but that's in a lot of agreements. Okay, entire agreement. This is all also in most. This agreement, this is what we talked about, constitutes the entire agreement between buyer and seller concerning their rights and obligations with respect to the sale and purchase of the business. Any agreements or representations respecting the business or its sale to buyer not set forth in this agreement shall have no effect except for subsequent written modifications. Okay, so this is basically saying, because we talked about a lot of things and we might have said something and promised it or not, if it's not in the agreement, it doesn't count. Okay, amendments. The agreement can be amended or modified by a written instrument. So it can't be amended or modified orally. So you can't call up and say, I changed my mind. I'm not paying you $100. I'm only going to pay you $88. That doesn't count. You have to have a written agreement with them where they agree to accept it. Okay, we talked about notices. This is the notice thing that says who to send notices to. I'm going to try to skip over that so you guys don't see that so much. What happened? Oh, it doesn't go any further. Okay. Assignment. Neither a buyer or seller shall assign any right or interest arising from this agreement without the prior consent to the other. Okay, so this is a transaction, a purchase transaction. The buyer can't assign it. The seller can't assign it because the seller owns it. The buyer can't assign it to anybody else without the seller's permission. So we may have agreed to buy something from you, buyer, from you, seller, but you can't, but it has to be us. It has to be us. We haven't agreed that we'll sell this to anybody. We can't just go to someone else and say, hey, we don't really want this. Can you want to take over? The buyer has the right to reject that. Okay, the agreement shall be binding on and inure to the benefits. This is in every contract. The agreement shall be binding on and shall inure to the benefit of the heirs, executors, administrators, successors, and assigns of buyer and seller. So basically this says it doesn't matter if they die or if they put their property to trust or if they do anything else, this agreement continues. So even though the buyer died and is not paying the money and the money is still owed, their successors, administrators, all of these people have to continue this contract. Okay, so governing, didn't we already have that, or that was in the other one maybe? Governing law, governed in accordance with California. Okay. Counterparts, the agreement may be executed in a number of counterparts. Each one is the same as an original, so we've got that in here. No construction against the drafter. That was the one we just saw, and the other one that I think is so important. It's been negotiated and prepared by seller and purchaser and their respective attorneys, and we're not construing this against any one person. And severability, we talked about that in that list. If any term, provision, covenant, or restriction of this agreement is held by a court of competent jurisdiction or other authority to be invalid, void, or enforceable. Oh, I must have forgot the last page. Hold on. I think I have it. Right. Oh, I don't have it, but it should say any term, provision, competent jurisdiction to be invalid, void, enforceable. Oh, and it ends with the provision is stricken and the rest of the contract is still good. So just because there's one thing in here that doesn't work, we're not throwing out the whole contract. We're only throwing out that provision and still living with the rest. So that is contract boilerplate. And I went pretty fast. So does anyone have any questions? It's super important stuff because, again, every single one of those was put in there because someone lost a lawsuit without having it in there. So make sure that if you're preparing a contract or if you're explaining it to a client and you get to the bottom part about, about this, you can explain. And this is that it's in every contract you're going to sign, not just purchase agreements. It's in every agreement you have with every vendor you ever signed, anything you ever offered to buy or any place you rented. All of this stuff is going to be in there. These are standard in California, and they're there for a reason because the courts found they had to be there. So any questions? No? Okay, I'm going to end with one thing. Is this it? No, this one. Okay. Oh, I forgot I'm not sharing my screen anymore, but okay. It's called, I just want to give you a little history just because for fun, why it's called boilerplate. The term boilerplate dates back to the 19th century when steel plates were used as templates to create steam boilers. The application of the term was used in the legal profession in the mid 1950s to describe how companies used fine print to get around the law. So, and that's kind of what it, they used to, I think another name for a boiler.
Thank God somebody explained that to me. It's been bugging me this entire time.
Yeah. I just like a little history. Since the 50s, they've been using it. Okay, no more history. Okay, anybody have any questions on anything? Yeah, go ahead.
Hi, Cindy. I have a comment. I think that's interesting. I can't remember which one it was, but it had to do with that once you finish with the agreement, it still continues because I have a client that's working with this attorney, right? And they supposedly went to arbitration, and the other attorney said, well, here's the deal. This is what we want. And there's no guarantee that this is going to happen after the agreement. And I'm like, isn't that what's
the point of having the agreement if that's not supposed to happen? Yes.
I know. I'm like,
I agree with you. I think that one, it makes no sense that all of our promises and all of our agreements are going to make it through the time we sign it and the time we. But again, that's not one that I see in every contract.
So,
but this was drafted by a pretty serious real estate attorney.
I was going to say, because those are things that a real estate attorney would do, right? Because
Yeah,
would
this was drafted by a real estate attorney. Yes.
Oh, okay. Thanks.
And now I use it for my own.
Okay. Great. Thank you.
Anybody else? Anybody have any other questions about anything that me or Terry could help you with? Boy, this is your chance.
Better ask them, because if you ask me, we're all in trouble.
Yeah. See, if there's no questions, you must have done a great job.
Yeah, or no one listened, and so they have nothing to ask. Okay, well, it wasn't my favorite topic, but it was a request.
Thank you,
So,
Cindy.
we will continue with something much more exciting next week.
Thank you, Cindy.
I thought this was good. Thanks, Cindy.
Yeah, and well, the reason I find it so
Amiable.
important is because
I'm
you guys are going to
serious,
sign a
though.
million, 100 contracts in your lifetime, and it's in everyone. They're in everyone, so you know what you're looking at, right?
Yeah, and then sometimes I think I'm reading something, I'm like, okay, we could agree to this, but it seems like you got a way out, like it needs to be worded or protected in another
In a
way.
different
So,
way, right.
yeah, that was helpful.
Well, okay, well, thank you. I know I'm a little early, but I have plenty of work to do. Thank you.
Thank
There
you.
you go.
Cindy.